The Louis Toledo case out of Florida. So let's talk a little bit more about this thing that's been going on in the Jessica Chambers case today. Adam Sostrin is joining us here live on LawNewz to kind of go over this. Adam, look, we've had a case where there have been people brought in and out of the court. The jury's been in court, deadlocked, back to deliberate, back in court, back to deliberate, back in court again. I count 4 separate times where they've been brought into court. And at one point we have a verdict read not guilty, but then when the jury is polled, they're not unanimous. Have you ever seen anything like this?
Never in my life. I would assume that this would be a Florida case.
No, it's Mississippi. So the one that we're talking about here, Jessica Chambers, it's unique.
Okay. Well, that was me being sarcastic.
Okay.
It's so unique. I would imagine that the defense attorney told his client. The attorneys had told his client, "Wow, we should be so excited." The clerk reads off not guilty. The prosecutor wants to get a poll from the jury, as the losing side always wants to do, to make sure that this was the exact opinion of the jurors. So the idea is you don't want a ground to overturn. So they poll all of the jurors. The first 7 come back guilty, 5 for not guilty. It's the most bizarre thing in the world. The jurors know that there's this unanimity instruction they're supposed to read. They're all supposed to come together and decide on the same thing when it comes to reaching a verdict. So this is so incredibly bizarre. The defendant must have been shocked, surprised. I've never seen anything like it.
Well, look, I mean, one of the things that shocked me, is that the defense didn't immediately jump up and declare a mistrial or ask for one. I know they can't declare one. But at this point, how can we respect any unanimous verdict in this case?
Well, it seems right now that there is already going to be a mistrial, provided, if you have 7 to 5, it's going to be a mistrial. That's what's going to happen.
Well, let's say it's not. How many times can the judge force him to go back in there? At this point,
sure.
They've been in and out 4 times.
Right. At some point, it's risky, and to preserve the record, if you're the defense attorney, you ask for a mistrial. Of course, your client's going to be on trial again after you do that.
Well, isn't maybe in this jurisdiction, yes, but in a lot of jurisdictions, this sort of a deadlocked jury is usually assigned to the state that, hey, wait, your case is not as strong as perhaps you think. And,
that's true. When you have a majority of the jurors saying guilty, I think when it comes to the more serious cases, oftentimes the judges do grant that next trial.
Well, here we're 7 to 5. This is not, 11 to 1. This is 7 to 5. I know that it's not 6 to 6. It's not a dead center split, but it's darn close. So, I'm looking at this saying, okay, reasonable minds may differ. Okay. I'm also looking at it saying, let's say they stay back there for another hour, and okay, this is just hypothetical. But what if they come back with something? Do we respect it or do we not? What if they come back and say guilty at this point?
Well, it's certainly it's going to be an interesting appellate issue if after the jurors come back and they all go back for guilty and the judge doesn't grant a mistrial. That's certainly a major issue. I've never seen anything like it. I don't know what's happening in the deliberation room. I don't know what's happening with the jury foreman if he's trying to strong arm, certain, guilty or not guilty. It's surprising. I would assume it would be not guilty because that's what it went back to the court with. Other jurors don't agree. He brings it up to the judge. It's so bizarre. Maybe there'll be a new jury foreman. I don't know what's happening.
Yeah, look, and it raises the question that I oftentimes ask here, and that is that there are jurisdictions that do not recognize this so-called dynamite charge. Some jurisdictions call it an Allen charge. It's not an Allen charge in Mississippi. They specifically said we're not following the Allen wording of the charge. They have their own wording. There's another case in the 1970s where they examined the issue. I'm still trying to research it while we talk about it here. But it ultimately does the same thing. A lot of jurisdictions call it a dynamite charge because it is designed to break up something that is locked together. Like an ice jam or rock outcropping, I guess, something like that. So, at this point, this jury has heard it 3 or 4 times, okay? A lot of jurisdictions don't even do it at all. About half of states say we do not do this because it might force a juror who is firm in his or her convictions to change his or her opinion merely because that juror fears or feels that the court wants at least some verdict. And so a lot of jurisdictions say we do not even do it at all. And then other jurisdictions say if we do it once and not again. Now, well, this jury has heard it now multiple times. And I know there is some federal precedent that says, there's a federal appeals court case that I read that said, okay, well, it's not error to read it twice. Okay, well, how many times do we read it? How many times do we force the jurors to go back and try to come up with something that's unanimous after they have said at least 3 times, as is the case here, that they are not unanimous and they're split close to straight down the middle?
Right. I mean, if they continue to being split, and then all of a sudden they come up with a verdict, it does make you wonder, how if a juror felt coerced in making that decision. It's absolutely a problem. It can occur whenever the jurors are told to go back. I can tell you in my experience, when I pick a jury, I always sort of want to ask at least one of the members in the panel, maybe the one that seems a little bit shy. Say you think the verdict should be not guilty, and everyone else is saying guilty. Do you just sort of go with the crowd? That's something that I do want to talk to the jurors about. I don't know if it makes much of a difference. At the end of the case, they're going to do what they're going to do, perhaps, but it's something that I always want to inquire about.
Yeah, I agree. Now, what do you make of the fact that at least I haven't heard it on the record, and I don't think it's been made yet? Why no defense motion for mistrials here?
Well, we just talked about this. It seems like in order to preserve a record, perhaps the defense attorney was thinking, especially if it's 7 for guilty and 5 for not guilty, I'm going to ask for a mistrial based on those numbers. If they're leaning towards guilty, that's something I'm going to want to do, or at least if for some reason I'm assuming there's going to be a not guilty, at least I can preserve the record by making a quiet request for a mistrial, because the appellate courts want to make sure that you made a record of these things.
Yeah, exactly.
That you indeed requested a mistrial. And if you don't do that, then you sort of waive that remedy. So it's a little unusual. It's a little strange. I don't know why that wasn't the decision. Perhaps the attorney was so shocked, was in shock and awe about what happened. He was just told there was not guilty, and then the judge was shocked, and he sent them right back in. The attorney didn't have a chance to speak up. But I'm assuming he would have requested it after the jurors left the room. So we'll see. It's a little unusual, sure.
Yeah, I mean, I was in shock too, but then the next thing that came out of my mouth was motion for a mistrial. Because look, I mean, when you're a defense attorney, you know this, Adam, your audience isn't necessarily that jury or even that judge. Your audience is also the Court of Appeals, because you have to remember that that's one of your audiences. So you got to, you have to conduct yourself to know that you have 3 audiences in a proceeding. And I mean, even in my state of shock, that was the next thing that jumped in my mind. So, look, they're still back in that room now. They've been back in for, another half an hour or so. Is there any chance that this jury can come together and even come up with a unanimous verdict at this point?
It doesn't seem like that whatever verdict they come up with in a half hour, at least to me, would appear to be I wouldn't be convinced that it would be a real verdict, actually reflecting the state of mind of each of the jurors. I couldn't be convinced of that in a half hour's time or 40 minutes worth of time. Perhaps if they think about it another day, maybe I'm a little bit more convinced. But it's always hard to say. If the defendant loses and they find for guilty, of course, I'm going to ask for a new trial if I'm the defense counsel.
Well, yeah, it's going to get denied at that point because the judge is just trying to kick this through to some version of finality, probably so, he can wash his hands with it. That's a guess, but I know a lot of judges want, they prefer to have a verdict rather than to retry a case. And if this winds up in a mistrial at that level, the prosecutor is going to try to retry it. That's going to be another massive enterprise because look, this jury had to be dragged up there from 200 miles away from home, and we talked about that the other day.
Right.
So going through the expense, the process, the time of re-sequestering another jury, bringing all of these witnesses back into this area. There was one day when testimony ran late, and I think it was probably because the one witness had traveled from some distance to be there. And
right.
Look, I understand that the defendant has rights, and I also understand that the court personnel doesn't want to go through the expense of doing this all over again.
Right. The court, in my opinion, is always sort of mindful of what's happening with the jurors, but he's also mindful of, bigger issues like, court problems.
What, did I lose you, Adam?
A case like this, what a nightmare that is. County. Are you not able to hear me?
Oh, it froze up for
Hello?
a split second, and I feared that I lost you, but you're back.
Okay, good. Well, the judge is always supposed to be mindful of, judicial resources. The presiding judge makes the calls about those types of things. And, what sort of a financial issue is it to bring in, and time issue? Is it to bring in all these jurors from hundreds of miles away to try a case like that? That's certainly on my mind. That's why, obviously, the dynamite charge issue is not very surprising. The judge would like to see a verdict in this case. I would imagine if they came back again and it said not guilty, for instance, and it was 7 for guilty and 5 for not guilty, at that point you would declare a mistrial. I would do that if I were the judge. I might not mess around with who's the jury foreman and get into all of that because obviously there's major issues happening in the jury room, and the judge really isn't supposed to pry about what's going on in there too. So this is a headache of a case. I've never seen anything like it.
I haven't either. And what makes it an especially severe headache, is this polling of the jurors, and at that point finding out that the verdict is indeed not unanimous. So at this point, the people sitting there in court, not us, but the people sitting there have seen their faces and heard them say how they're voting.
Right. That's usually something you never find out about. But there's a reason that they have polling. They want to make sure that these things are unanimous. And when it does so happen that there is a split after the jurors saying that something was unanimous, I think that the first thing the court would do would be to send them back and remind them, of course, of the unanimity instruction and go forth.
Yeah, a couple of other things that have happened today, Adam, I want to bring you up to speed on, and you may be hearing this for the first time from me, but here's the bottom line. Our freelance producer, we hire freelance producers depending on what location we're doing a trial in, so our freelance producer posted on social media at some point in near recent memory that she had heard that the judge took a part of a cotton plant, picked the plant and gave it to a reporter. And she took a photo of it and posted it on social media. Okay. According to our freelance producer, one of the investigators who was on the stand in this case, who is also in charge of courthouse security, came out and banged on her window and accused her of race baiting and ordered her not only to leave the courthouse, but said she better get out of the county as well. So she hightailed it on out of there. And we wrote it up on LawNewz.com. It's there for anybody who wants to take a look at it. But what does that say to you?
That says to me that there's a lot of underlying issues in this county.
We can begin to try to disseminate what those may or may not be. The same person was on the phone with our editor-in-chief, Rachel Stockman, earlier today, and Rachel tried to hit him with, hey, look, we've got a First Amendment right to report, and we have a First Amendment right to be present. And he sort of punted on that issue and said, well, you can't do it from my courthouse parking lot. So
well,
I'm not...
I don't know what to say. I mean, it seems like this is just getting more and more bizarre. I've never heard anything like that. I understand the underlying racial tones with respect to what occurred with the cotton plant. I don't know what to say. You have me flabbergasted. I guess.
Well, I don't like to blindside my guests, but in this case, we didn't have a lot of time to chat before you came on the air. But look, I mean, we were watching what appeared, at least on the surface, initially in this case, to be a pretty orderly proceeding. Witnesses were moving very quickly. The attorneys were very efficient, not beating around the bush, going right to the heart of the matter, keeping the testimony limited to what's relevant, not going around for all sorts of things about everything else that may or may not be happening in the world. And yet we've got the jury in and out 4 different times today. We've had this other incident, okay, which unfortunately involved us. But, I'm trying to figure out exactly where things begin and where things end here. And, is this thing just degenerating in its last day? Are tempers just really that flared down there, or what's going on?
It sounds incredibly unusual. I guess there's probably going to be a lot of news about this, with respect to perhaps the cotton plan, and with respect to what the jurors did in this national newsworthy trial. I don't know what to say. It's bizarre that this isn't a Florida case, that this happens to be a Mississippi case, but maybe this is par for the course sometimes, that these things do occur and I just don't hear about them.
Okay, we have a clip of the phone conversation between our editor-in-chief, Rachel Stockman, and this person who was on the stand, also in charge of court security, about exactly what happened here. So let's listen in, and we will hope for a little bit more reaction on the tail end of this.
Okay.
Just threatened to arrest our reporter. But sir, let me ask you a couple of questions about this, because all she did was post a picture on social media. She did not do anything illegal.
No.
Just threatened to arrest our reporter. But sir, let me ask you a couple of questions about this, because all she did was post a picture on social media. She did not do anything illegal.
No. Her conduct is kind of like a racial issue or something like nothing to do with race.
I understand that, but even on its face, you can't just arrest someone for posting something that you think's inappropriate. And
But I can, after I remove somebody from county property and tell them not to come back and they come back, I can.
but let me ask you this. I took a look, because I was concerned about this, so I took a look at what she posted, and we have a copy of it. And all it says, and I'm pulling it up right now, it's a picture of the cotton.
You don't have to pull it up. You don't have to pull anything up, because y'all just posted on your LawNewz website that White Circuit Judge during racial charge case gets cotton off the white reporter. You made it a racial issue.
Right, but then you escalated it by, we weren't even going to do a story about it, but then you kicked out our freelance producer for posting about it.
Yeah, well, guess where your freelance producer was this morning when I tried to go talk to her about it? Asleep in her car.
Well, she was up all night concerned about this because she heard that she was in some sort of trouble. So I guess she was sleeping in her car. But listen, why? I still don't understand why she was kicked out of court property. She says she was told she has to leave the county.
Well, I said she had to leave this county property. She wasn't listening.
Okay. But it's public property, and she did not do anything against court orders. So, I'm just trying to understand why she was kicked out.
Ma'am, she was removed from the courthouse property for inappropriate conduct.
she was removed for inappropriate conduct. What was the inappropriate conduct?
Trying to make a racial issue out of something that has nothing at all to do with race.
Right, but she has a First Amendment right to post whatever she wants. You can't tell her what she can and cannot post.
I know the Constitution very well, ma'am, but she's not going to do it from my parking lot.
But you're suppressing someone's speech. Listen, I'm not. This is very concerning to me as a journalist that you would try to suppress a reporter's speech just because you thought you didn't like it. All she wrote is the judge dug up a cotton plant and brought it to some girl in the media. I mean, she just was reporting what happened. The judge gave the reporter a cotton stalk.
Answer me a question. What does that have to do with the guilt or innocence of Quentin Tellis?
It doesn't have anything to do with the guilt or innocence of Quentin Tellis. It's something that happened at court, and she's a reporter, so she reports on what's going on.
First of all, and it's totally misshapen. I delivered that to that report.
From the judge?
No, from me. The judge never touched it. The judge didn't have anything to do with it. I delivered that to that lady, hand delivered by Barry Thompson.
Sorry, say that again? You delivered the cotton stalk to the reporter? Sir, can you hear me? Sorry.
Well, that's how the conversation started, and that's how the conversation ended. So, Adam, I know you had a chance to brush up on this a little bit more here. You know, look, here's the chain of events, as I understand them. The freelance producer that we had hired to help us cover this trial, have our equipment there locally, observed this, took a photo of it, and just posted that it happened. And then at that point, everything blew up, and the guy who's head of courthouse security, who also testified in this trial, went after her in the parking lot. You know, there's a couple different versions of it, but what do you make of it?
Well, I'm assuming they take anything regarding race very seriously, and what happened with respect to the person working for LawNewz was clearly sort of a violation of their rights. We have this First Amendment right. This was clearly government action. What the reporter did, in my opinion, doesn't appear to be unlawful any which way what this person did, you know, posting a picture. The court instructing, you know, some sort of security, law enforcement, a sheriff's deputy perhaps at the courthouse to tell her to leave county property based on expression that she was lawfully able to make. There appears to be some sort of violation here, and it's so unusual. I just don't know what is par for the course here. It's so bizarre.
Yeah, I'm not sure what to think of it either. I mean, look, you know, there's a lot of back and forth online about this. The report has attracted considerable attention. A lot of people saying, you know, hey, look, this cotton plant was inappropriate on its face. Other people turning around and saying, what's the big deal about it? So there's this back and forth with that, you know, and back and forth as to the facts. You know, our producer was pretty clear that this somehow came from the judge. And yet you heard the guy who's head of courthouse security saying that, no, this thing was from me, okay? And, you know, it's just going back and forth, back and forth, back and forth. And added on to this whole thing about the jury basically being, you know, in and out of the courtroom all day today, and it just seems like this thing degenerated today into a fiasco.
Absolutely. Well, you know, the judge doesn't have to be the person calling the shots if it's actually security, government security at a government building, saying you have to leave the premises by something that you something that you had expressed, some sort of statement that you made. So that's still a problem. I guess maybe we'll never know if the judge is the person who made that call, or maybe this is something we will find out. But this is clearly something. I'll use the same word. This is something that has degenerated. I can't understand it. Probably getting a lot of. They get so much national exposure. And it may also be equally rare that we're dealing with a jury that I just cannot fathom. I don't know what's happening there. I don't know what the jury foreman is doing.
Yeah, I'm not sure. I'm not sure either here. I mean, we know that the vote was 7 guilty, 5 not guilty, and they went back in for another round of deliberations. You know, it's interesting, those numbers, because it is the inverse of the racial makeup of the jury. There are 5 whites, 7 blacks, and we've got 7 guilty, 5 not guilty, but I think it would be impossible or highly unlikely to say that it's a straight breakdown through racial lines, 6 men, 6 women. But, you know, look, it's a diverse jury. It's a diverse jury racially. It's a diverse jury from a gender standpoint. And apparently it's a diverse jury as it comes to the decision on the actual vote here. So it looks like they're going to, you know, keep deliberating through the evening, trying to see if they can come to some kind of a unanimous decision.
Well, I'm assuming they're supposed to break at what time? 5 o'clock? I don't know what the instructions were.
Because they're a sequestered jury, they've been going late almost every day. Initially, this thing was billed to possibly be a 2-week-long trial. And yet here we are on the Monday of the second week, and the jury got the case. The jury actually worked on a Sunday. They did work a little bit yesterday. They're sequestered. They're a long way from home. And the members of the jury were pretty clear that they wanted to get through this as quickly as possible. So we had testimony up until, you know, the 8 o'clock hour and later here Eastern time. I realize that's 7 o'clock Mississippi time. But it's a case that's pushed things well late into the evening. So they may deliberate quite late today. We're not exactly sure.
You know, and I understand that just because of the logistics. But this seems to be one of those cases where it should remind attorneys that do try cases to really explain to the jurors that if they're not able to make a decision, that they don't have to make one when they're doing their closing argument. It's not an argument for them not to follow the law, but it is a lawful statement. It's true that they don't have to come to a decision. If they're not able to reach a decision, you know, then they are deadlocked, and that's something that occurs in these cases. And that's okay. It seems to be perhaps they thought they were forced to come up with one decision or another, and there's nothing in between. Although they were deadlocked at some point, it would seem that this is just one of those instructive cases that you always have to make this point to the jurors that, you know, if you're not able to make a decision, you're not able to make a decision. But we think the defendant in this case is not guilty because of, you know, X, Y, and Z. But these things should be made plain to the jurors before getting the case and trying to make a decision.
Yeah, I agree. I mean, and I believe that that's part of what was done when the judge finally brought them back out for the 4th time. That the wording of the statement from the judge to the jury was basically, you have 3 options. Either you're all unanimous one way, all unanimous the other way, or you come out and say that you're not unanimous. It's one of the 3, not say not guilty, and then when I poll you, find out that you're split down the middle. That's just not one of the 3 options. And I think maybe, and a few other commentators have been saying that it, you know, that's what it may be, is they just might be confused about the process here. A lot of people saying that online, a few people saying that here internally at LawNewz, that it may just be that they think, oh, well, if we can't agree unanimously on guilty, therefore it has to be not guilty, and that's why we saw one of the other things that we saw.
I think that's something that happens. And I think, unfortunately, some judges don't make it absolutely clear. You're not able to make a decision. You're not able to make a decision. Then, you know, that's okay. I rarely hear that from the court. Usually he'll send the jurors back to make a decision. And they're not so maybe clear on the acceptability of the possible, you know, hanging jury.
Yeah, well, we're going to wrap up for the day, but before we do wrap up for the day, we're going to bring on our freelance producer, who we're going to call up in just a second here to try to get a better sense of exactly what went on down there. So Adam Sostrin, attorney, we always appreciate you joining us here on Law News for a bit of perspective on a day where the events are changing by the second.
They are. It was a lot of fun. Thanks for having me.
Okay, we'll see you later.